Welcome to the Wills and Estate Transmission Podcast, brought to you by De Groots, specialist lawyers in wills and estates.
Hi, and welcome to the Wills and Estates Transmission Podcast, brought to you by degroots.com.au. And today we're welcoming a frequent guest back, Max Williams. How are you, Max?
I'm great, thanks, Tony. Great to be back.
Awesome. Okay, so today we're looking at after the grant of probate or letters of administration. So we've had some feedback from listeners over the period, and we're looking today at a bit more later after the will has been dealt with and the probate has been issued. They've got a few questions that we'd like to ask today and cover off.
Okay, fire away.
So the first one is advertising after the grant. So there seems to be potentially some requirements on that and how that actually works. So can you step us through that?
Sure. So after the executor or the administrator takes out a grant of probate or administration, one of the frequent next steps is about advertising for claims. Now, this is a bit different in each state as to what these advertising requirements are. In New South Wales, for example, there's an online registry that the court operates that you can publish this notice on, whereas in other states like Victoria, for example, you might actually have to publish in a physical newspaper still. So you do need to be wary of the differences, but the principle's still the same, and that's the executor needs to put out there that they've obtained a grant, that they're going to be administering the estate, and they're intending to distribute that estate fairly soon. Now, the amount of time that the executor needs to give these potential claimants, again, will vary from state to state. It might be 1 month, might be 2 months, but whatever it is in the relevant state, that period is given to these potential claimants to let the executor know, to put their hand up and say, I'm over here, I've got a particular claim. Do not distribute the estate without considering my claim. Now, what could these claims be? Well, it might be as simple as a debt. It might be a creditor who says the deceased owed them money. And so they can write to the executor and say, here's the invoice that hasn't been paid. Make sure you pay me before you distribute the estate. Or it might be something like a family provision claim where you've got someone who's been left out of a will and they're wanting to contest the will on the basis that they haven't been adequately provided for. Now, if the executor does this and they put the notice in where they need to put it and they wait the required period of time and no one says anything, then when they go to distribute the estate, if someone down the track comes out of the woodwork and says, well, hang on, the deceased owed me a debt, the executor is legally protected. And that's really the purpose of this whole exercise. It's to provide the executor or the administrator with legal protection when they go and distribute the estate. Now, on the flip side of that, if they do this process and someone does put a claim forward, but the executor ignores it and goes and distributes without paying the debt, or doesn't wait the requisite period of time and distributes early, and someone later comes and says, I've got a claim, then the executor in that case may be personally liable to pay whatever that amount is. They might get in trouble for that. So it works in both senses, but it's really important that the executor or the administrator puts that advertisement in so that they can get that legal protection that legislation offers.
Fantastic. So we're talking about executors, and we'll cover it off again. Payment of executors. So how does that actually work?
Well, the starting point is that executors are expected to do their job free of charge. That's the general expectation. Now, there are two general exceptions to that. One is in the case of what we will call a professional executor. So that might be someone like myself who's a solicitor, or it might be someone else like an accountant where they're filling that role. There might be a clause in the will that allows that professional executor to charge their their time at a professional rate to compensate them for that time that they've spent on the matter. However, if you've got a non-professional executor, so maybe just a family member or a friend, they are able to seek payment of what's called executor commission. Now, technically every executor is able to do this, whether they're a professional or a non-professional executor, but usually where you've got a professional executor and they've got a clause in the will that allows them to charge their professional fees, they won't bother with commission. So it's more of an issue where, or could be more of an issue where you've got what I'll call a non-interested executor, in the sense of someone who's been appointed as the executor who's not a beneficiary of the estate. So they're not going to get anything at the end of the matter. In that case, they may want to seek some sort of payment or remuneration for all the what's termed the pains and troubles of taking on that role. Now, in the first instance, an executor who wants to claim executor commission will simply seek the consent of the residuary beneficiaries, so the beneficiaries who are going to receive the residue of the deceased estate. And as long as it's a relatively reasonable amount that's being claimed, I find in my experience the residuary beneficiaries will usually just agree to it, and that can be documented in a deed of settlement. But where the residuary beneficiaries don't agree, then the executor would need to actually make a formal application to the court. And as part of that, they'd need to submit all the accounts for the estate. And then, again, each state, it's going to be a bit different, but the general rule is it's a percentage of the estate. Now, there are three broad categories that the courts break the estate up into, or rather the executor's tasks in administering the estate. They break them up into these three categories. So there's a capital realizations, where they've perhaps sold a piece of real estate. There's income collection, so perhaps they've rented, or there's a rental property and they have to collect rent. And thirdly, there's assets that are distributed in specie, which simply means the executor's transferred the asset in its state to the beneficiary without selling it. So that might be shares, for example. And then there's different percentages that apply to each of those categories. But I always say, just as a really rough general rule of thumb, it works out to be about 2% of the estate. You know, it might be more in some cases, might be less, but you know, in giving quite sort of general advice to people, I say about 2% of the estate, and that would be executor commission.
So we touched on it already in relation to rent. So what if the deceased owned property with someone else?
Well, it depends how they owned it. So generally there's two ways to own property, real estate, with another person or people. The first is what we call joint tenants, and that means that each owner owns that property jointly, and when one of the owners passes away, the other owners automatically inherit the total property by way of survivorship. So in practice, what's required is you produce a copy of the death certificate to the relevant land titles office, and the deceased person's name simply removed from the title. The other way is what's called tenants in common, and that's where the owners can hold varying shares, so they don't have to be equal. You could have one owner own 1%, the other own 99%, or they could be equal. But the main difference with tenants in common compared to joint tenants is that each owner can leave their respective share in the property to whoever they wish pursuant to their will. So in the first type, joint tenants, the survivor gets the property automatically and the other owner can't do anything about it. With tenants in common, you could leave your share to the other co-owner, but you could also leave it to other people. So to come back to your question, if the deceased owned a property with someone else, the first thing you need to do is find out how they owned it. If they owned it as joint tenants, then that property just automatically goes to the surviving owner. It's got nothing to do with the will, it's got nothing to do with the estate, and if it's a rental property, that means that the surviving owner will then be entitled to all of the rent. But if it's the second type, tenants in common, well, the deceased share of that property will form part of their estate. And if it's a rental property, then that relevant percentage of the rent would form part of the estate as well.
Now, just to clarify, so if I inherit that part of the property or inherit the entire property, any debts in relation to mortgage also transfer across?
Generally speaking, yes. So there is a rule that says that if a debt is secured against a property and someone inherits that property, then the property bears the burden of paying that debt. Now, that is always subject to a contrary intention in the deceased person's will. So a deceased person could say, for example, I don't want the property to bear the burden of that debt. Instead, I want the money in this bank account to pay that debt, or I want my life insurance to pay that debt, or they might actually specify how that debt is to be paid. But if they don't do that, the presumption is that that property bears the burden. And so practically what that means is if the deceased person has left that property to someone else and it's subject to a mortgage, if the beneficiary wants to keep the property, they will need to effectively refinance the property.
Right, okay. Now, a friend of mine recently had to go through all of this, and one of the things she was talking about is trying to get money from financial institutions, and being here in New South Wales, she wanted to get money from a bank in Queensland, and they initially insisted on original documents being sent. And of course, we shouldn't be sending original documents in the post because we know what can happen. So how do we deal with that sort of thing?
Well, I must say I've never encountered a bank asking for original documents. What they may be requesting is, and this is admittedly a confusing way to frame it, but original certified copies of the documents, in the sense that they want a copy of the, say, copy of the will, but it's got a wet ink signature from the person who's certifying it. And if that's all they're after, they just want certified copies, then sending that by post is perfectly fine. But if, on the other hand, they're actually asking for, I don't know, the original will, well, of course, that's a big no-no, and you definitely shouldn't be doing that.
Okay. So talking about things like that, so we've got these issues, of course, these days, and you touch on life insurance, but superannuation, they're known for being a little bit tricky, but getting money out of those. So how do you recommend that people do that?
Well, it depends in what capacity they want the superannuation. So if we're advising an executor, there is a claims process that needs to be made. Actually, I might take one step back. The first step is to work out whether, if we're talking about superannuation, whether the deceased member left a binding death benefit nomination. Because if he or she did leave a binding death benefit nomination, there is no claim process essentially. And as long as it's a valid nomination, the superannuation fund will simply pay the death benefit to the person or persons that have been nominated. End of story, nice and simple. Where it gets complicated is where the deceased member didn't make a binding death benefit nomination, or the nomination they made has lapsed, because they usually lapse every 3 years. Now, in that case, there is a claims process. And usually what the superannuation fund does is they try and work out who are all the relevant people within the sphere of the deceased member's family or next of kin. And they will write to each of these people and invite them to make a claim. Now, just because you make a claim on someone's superannuation doesn't necessarily mean you'll end up receiving any of the superannuation, because where a deceased member has not made a binding death benefit nomination, it is at the full and absolute discretion, effectively, of the superannuation fund as to how and to who they will pay this superannuation to. So, coming back to what I was saying before, if you're the executor, you have a duty as executor to apply to have the deceased member's superannuation paid to the estate. If you're not the executor and you're just someone who is the deceased member's next of kin, then you can make a claim on your own behalf that you want the superannuation paid to yourself. And as part of that, depending on the nature of your relationship, For example, if you're a child, that's nice and straightforward. But if you're claiming as a de facto partner, you might need to furnish the superannuation fund with the necessary evidence to establish that you were the deceased de facto partner. And we often see some disputes about that. The other area of concern, going back to the executor, is you might have an executor who was the deceased spouse. It's not unusual for a deceased person to appoint his or her spouse as their executor, quite common. And they might leave all of their estate to the spouse, or in the case of a blended family, they might leave some to the spouse and some to the children from the first relationship. Where executors can get into a bit of trouble is where the executor is, say, the spouse. They might make a claim to have the superannuation paid to them personally. And there's a very obvious conflict of interest there, because as the spouse, they want the superannuation, but as the executor, they have a duty to, as I said, get it paid to the estate and paid in accordance with the will. And there have been cases in the past where the courts had to step in and say, well, no, executor, you shouldn't have had it paid to you. It needs to go to the estate.
You've got a little interesting little question here about legal actions and the deceased. So if there are ongoing legal actions, does that cease or stop with the deceased, or does it continue on? And what are some of the rules around that?
It'll depend on the nature of the cause of action. As a general rule, any legal actions that are taken by the deceased will continue after their death, and similarly, any legal actions taken against a deceased person will continue after death. The executor in that case will then assume the deceased's role in the litigation. One of the common types of litigation where this can be relevant is family law proceedings. Now, we're not family lawyers, so I don't want to go too in depth into this, but just to mention it in passing, that if a deceased person has commenced, say, a property settlement proceedings against their former spouse, and they happen to die in the middle of it, then my understanding is that the deceased executors can continue that to resolve it. But it is important to note that every cause of action is different and unique. And for example, in the case of a family provision claim that a person makes, where they're contesting someone's will on the basis they haven't been adequately provided for, if they were to die in the middle of those proceedings, well, I would have thought in most cases that's probably the end of the cause of action, because they've died, they don't have any needs anymore, really. So it's not always the case that the legal proceedings will continue. Again, you do have to bear in mind the specific type of cause of action that's being prosecuted. But as a general rule or a starting point, yes, they will survive.
Okay, we've had this come up before in relation to so-called not-for-profit or tax-exempt bodies. And I just want to touch on that again, the caution about leaving your estate or parts of your estate to not-for-profits, because there's different types of not-for-profit situations. Can you just go over that again?
Well, it depends on the type of asset you're leaving. This is actually quite a complex area, and probably not appropriate to do on a podcast, but just to say in passing that if you are thinking of leaving certain assets to a charity, you need to give some serious thought to the tax implications for doing that. So, for example, if you're leaving a piece of real estate to a charity, there could be capital gains tax implications for doing that. And you should discuss that with your accountant and financial advisor. But yeah, if you're leaving anything more than just a sum of money to a charity, if you're leaving specific assets, you do need to give some thought to the tax implications.
Thank you very much. Anything else you'd like to add?
Well, I think what we've canvassed a lot of different issues in this episode that may or may not be relevant to an executor. But I think what really underpins all of this is that it's really critical that an executor seeks legal advice in acting as an executor, because as I've just touched upon very briefly in this episode, there are a number of areas where an executor might open themselves up unwittingly to personal liability, because there's all sorts of obligations and duties that an executor has that if you don't do this every day, you're just not going to know about them. And so seeing someone like ourselves, specialists who know this area, we can provide that executor with the peace of mind and hopefully the protection that these various bits of law can provide them, so that they can rest easy at night knowing that they've done their job properly and that they're not going to be liable.
Those fees can be covered by the estate itself.
Oh, of course. So legal fees for an executor administering the estate properly and legitimately, of course, that's all covered by the estate, so they're not out of pocket. Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website, www.degroots.com.au, and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.